before we proceed with the
We agreed that we are coming back at 12 noon to argue the preliminary objection, but unless you are withdrawing it, we proceed with it. You are coming today to argue, to have some reports by the IEBC, the National Land Commission. You swayed us from that. Then you said you have a preliminary objection, which you always had and which you filed last evening. The other parties who have not served, but they are ready to proceed with it. I gave you time to prepare for it. Can we go into it?
Your Lordship, my client has a right to state.
Can you go to the preliminary objection? Because if you raise the preliminary objection, and the preliminary objection disposes of this matter, that's the end of the matter.
Whatever the court here what my client wants.
What is it? In the summary, what is it?
I have been instructed that the court recused itself from this hearing this matter.
Have you made
For
an
reasons.
application? Yes, for reasons.
For reasons, today, the Lordship, it's a mentioned date. It's not a hearing date for anything. Two, the parties have not complied with the element of the Civil Procedure Act. So summarily making substantial or substantive orders on a mentioned date is clearly biased towards the second interest.
What time? Now look here. At what stage can a preliminary objection be had?
It can be at 10 stage.
Eh?
At 10 stage.
At any stage?
Yes.
You raised it.
Yes.
You brought it to court. You said you wanted to had fast. The court places aside the other matters and says that it is ready to hear that preliminary objection. The other parties say they are not ready.
Your Lordship.
In the first place. Secondly, when they were told, when they asked whether they had been served, they said they had not been served, that they are ready to argue the preliminary objection. You said you could not argue it, you are not ready. You said you are not ready.
Yes, I said so.
You are given 1 hour to prepare. They were not even aware of what the objection was about. Then, they said they are ready to prepare and be heard on it. At one stage, they said they wanted it heard fast. You said, no, you have been given an hour. And you
What is the court which was prompting? My Lord.
Now, is there, listen. Are you saying that the court has been compromised?
I am not saying so. But the way the court is conducting itself, it appears that we will not get a fair hearing in this matter.
You will not get a fair.
Yes.
Can you raise your preliminary objection?
On the issue.
And see on the issue of the jurisdiction of the court, and then we proceed.
That's why I'm coming, Your Lordship.
Now, Mr. Olina, he has said that he wants the court to recuse itself. What do you have to say on that? No, Mr.
I am not finished, my Lord.
No. I said I don't want side shows. You either argue the application, or you withdraw it, or the others argue it, and I make a ruling. Mr. Kosok, we cannot be here. We are paid our salaries as a court. When you are saying that some people have been incited there, and then those people go on fighting when this court is supposed to resolve their issues. That is one. Or we keep this matter in abeyance. People don't pay revenue because they don't know where the boundary is. And as Mr. as the petitioner said the other day, they are not able to provide services because of the boundary issue. Yes, Mr.
Your Lordship, indeed the sentiments by my learned senior are regrettable, and you had given clear directions on what you are coming to do this afternoon. Your Honor, you remember when we were in court last time, he raised the preliminary objection. He indicated that he is going to raise a preliminary objection. He somehow mentioned it while we were in court, and then now formally he filed it yesterday night. As diligent as I am, when I heard that he is going to raise a preliminary objection, and he had already said under what grounds he is going to raise the preliminary objection,
no, let's not even go into that.
PO is premised on the hearing of the motion.
Can we?
So there is no motion here being had today. Today's a mention. That's what I'm saying.
Maybe your lordship to guide the parties and maybe to chip in, to guide the parties and the courts. Can you allow me 1 second, your lordship?
I don't think I'm allowing any sections now.
This is not a section to assist the court, your lordship.
The preliminary objection is dated 12 May 2023. Yes, what do you have to say about it?
As the court ruled about the issue of recusal.
I'm not even entertaining it. Because there is nothing on record on that. Courts, this is a court of record. You had a whole hour to make that application. Can you have the preliminary objection? You said you are not ready in the first place. So that is the truth of the matter. You are buying time. Can we hear this preliminary objection?
The PO, your lordship, is dated 24th May 2023.
Is it 24th or 12th?
24th May 2023.
Are we reading from the same script?
There's a different PO which we are not pursuing. That is why the secretary provided. There was an earlier PO which we are not pursuing. We are participating fully.
This by Mr. Day?
Yes, yes, yes.
I don't even have a copy.
It's in the file.
Favor the court.
Yeah. Yes, proceed.
The lordship is dated 24th May. We are raising 4 issues. One,
How much time do you require?
20 minutes.
No, I'll give you 5 minutes each.
Your lordship,
Because it's in writing, I'm able to read. Just highlight the sign.
Can it be taken in writing down that the court is asking me? This is a matter which you have rightly said is weighty between 2 counties. You are just rushing me to argue.
Does the court have authority and the right to give parties the time they should react?
Yes, of course, and I can't even in the
So
law.
when I reduce the 20 minutes to 5 minutes, you say it's harassment.
Yes, I have to go through, my lord.
So you want all the 20 minutes. The court
Yes.
should not reduce.
I am requesting.
No, the court should not reduce it at all.
I am requesting that I be
No,
given
the
20
court
minutes.
should not reduce it at all. When you say it's 20 minutes you want to take, the court must allow you the 20 minutes. If it does otherwise, it is harassment, isn't it?
Your lordship, you are putting words into my
No, you are saying it's harassment. If I don't
Yes.
give you 20 minutes.
When I ask for 20 minutes, you say 5
then
minutes. Your
I'm
lordship.
giving you 8 minutes.
We have raised issues on.
You have already taken 2. Yes?
Your lordship, we have raised issues on the petition itself, in that the petitioner has not adequately provided the court with the allegations of infringement.
Has not adequately.
Provided the court with particulars, material particulars on the allegations of infringement under Article 22 of the Constitution. There is a case here there where which we have highlighted an Narita Karemi in Jeru for the Republic 1979. That is a notorious case. The court can have a chance and see. We are also arguing that the particulars are not clear, concise, and precise in a manner that correlates with the alleged infringements and actions of the respondents, if any.
They are not clear, precise.
Precise. They are not clear, concise, and precise. Pleaded in a manner that is correlated to the allegations of infringement. There are also allegations that the petition has rights have been compromised, for example, under Article 22, but they are just pasted in the legal foundation of the case. They are not related, or they have not been demonstrated on how they infringe on the rights of.
So the particulars are not?
Are not particularized in the legal foundation of the petition. It's there.
So they have not given
particulars of infringement.
Given the foundation.
Our point, Your Lordship, is that by just writing them down in a specific paragraph without relating them to infringement, then this petition fails to be a petition, a constitutional petition. We're also saying under Article 189.
So this petition fails to, therefore fails
to be a constitutional petition for failure to adhere to the principles laid down in an Narita Kareni case. Second, Your Lordship was saying Article 89 of the Constitution gives IBC the powers to determine boundaries, and there is a specific period given.
So that's the second point.
Yes, that's the second point. Article 89 and Article 89, 2 and 3.
Give the IBC
the power to review boundaries of constituencies and even words in a period. Yes, the period is given not less than 8 years and not more than 12 years. So it means that the first stop for the petitioner should have been at the IBC.
So the first port of call. Is it the first?
Yes, the first port of call should have been a petition to the IBC. So that now, if you go to the prayers given under paragraph 66,
so the request should have been to
the IBC.
Should have been a petition to the IBC.
That's what I'm saying. Such that, Your Lordship, you will find that the prayers now under paragraph 67, prayer 67, C, D, E, F, G, I, J, and K of the petition cannot be granted by the court. For example,
now another point.
No, that is, I'm still under that issue.
The fact that IBC is the one that should deal with the matter.
That is what I'm saying. And it's
I'm asking because I didn't get it.
I'm saying, because of that provision in the Constitution, the court now cannot grant the orders prayed for in the petition. The petition, the prayers are at paragraph 67. And I have named them as C.
So the court cannot, therefore, entertain.
Yes.
Yes.
The prayers sought in 67C, D, E, F, G, I, J,
So the prayers
and K.
And 67C, D, E, F, G, I, J, and K.
Another point, this court lacks jurisdiction in granting prayers 67A, B, and H.
Prayers
67A and H, A and H. For reasons, yes. For reasons that the prayers sought in A, for example, you are in A, And Declaration B, and is hereby issued that forcing the residents of Keroka town to pay double taxes is a gross violation of the affected traders, properties, and
So such prayers.
Yes, the court does not have jurisdiction. If you look at the provisions of Section 13 of the Environment and Land Code, so those prayers cannot be given. We are also arguing
such prayers are not within the jurisdiction of the BSC.
this is purely on issues of collection of taxes, which is not the province of this court. And the province of this court is enumerated Article 13.
You have said it's A and H.
A and H. The other ones have said about them.
The others?
I named C, D, and all the prayers I've named them. They are about up to M. And the issues, of course.
Okay, I've got the point.
If now we also arguing that if you look at the prayers sought in the main motion, the notice of motion, there are no prayers the court can grant. All of them. Those are orders in the province of the judicial review.
So, and the purview
of a judicial review proceeding, which is not the province of this court in terms of collection of taxes and allocation of Nyamira to get, for example, Your Lordship, paragraph prayer 2, A, B, C, D, and the prayer 3, 4 of the motion cannot be granted by this court.
you know,
The issues of permits and all those things.
You have 8 minutes, you have not even 2 minutes more. Just proceed. You will cover that.
So, Your Lordship, we are saying, on those grounds, the bill should be upheld, and the motion and the petition be dismissed with costs. I can supply the authorities to the court with
There is something you had intimated earlier on about intergovernmental. That this ought to have been a matter under intergovernmental
Thank you, Your
Relations Act.
Thank you, Your Lordship, for reminding me. Section 20, Section 20 of the Intergovernmental Relations Act. Just
Yes.
Section 20 for these issues that they can be resolved. That they can be resolved at the Council of Governors level. Section 20, I'm referring to Section 20. Among the functions of
It should be resolved by?
they can be resolved by the Council of Governors, under Section 20.
By
Shall, the word here is shall,
by
which
the
is used.
Council of Governors. Yes.
And the Section 30.
Because they are intergovernmental.
Yes. There is a part 5 in section. Part 5 of dispute resolution mechanisms. There is Section 30. As defined the disputes, has given the way the courts shall apply the same when they have a dispute. That is between the counties and themselves. That is one.
So you had also said something, so you've exhausted Article 89, and you also talked about, now what you are arguing now is Section 189.
Yes, we also said in the final.
In the morning, you also so
those issues were raised, Your Lordship.
I thought in the morning you also talked about Article 159.
That's what I'm addressing finally.
You have not.
I have opened it.
You know it's it's me now who is guiding you, sort of. Because you are related to all these issues. Everyone is very sharp, Mr. Osota.
We started on
And I don't deal with matters of... But you started? What have you just said?
We started on September, which was high. You know, sometimes your points.
I know I don't lose my temper, but when you want to take me round and round and round, I always take you back. And nothing personal, Mr. Osota,
yes.
Nothing personal at all. But I hate when my court is taken round in circus. Yes.
So
under Article
59.
59.
This
159.
Yes. This petition cannot be rescued by Article 159. The petition and the motion itself
Cannot?
It's not a matter which can be said to be technical or procedural technicalities on due regard to procedural technicalities. This goes to the root of the matter. If one cannot state clearly what has been infringed, and if one files a matter in a wrong court, if there is another relief, for example, judicial review available to that party should choose that mechanism which is available.
I've got a point, but let me ask you this. Today, you can bring of certiorari either by way of the Constitution or by the way of judicial review. Correct? There are those two procedures. It's for you to choose which one you want. Correct? So likewise here, you can choose which way to go. Either by way of a constitutional a petition or by way of judicial review. And I even feel judicial review is lacking because is there a decision that has been made which you would want reversed if it's certiorari?
Actually, I should thank you for reminding me. I'm sorry that I have a cough. If you look at the provisions, I woke up with it.
Maybe that's
so
that's
I want to bring you to, for example, a prayer D, when they say that a declaration be and is hereby issued that Parliament should enact enabling legislation to implement Article 94 and 188 of the Constitution. Article 188 of the Constitution is about issues of boundaries. Already we have an act and we have a body which is...
I cannot even hear them on that.
Yes. So that's what we're saying.
I cannot even hear them on that. I can't.
Those are the prayers. That's what we're saying. Some of the prayers they're asking, they are spent. They are spent. And some, the court does not have jurisdiction.
No, it may have jurisdiction, but only that the court can do is to state that whatever you are praying for has already been provided. So how many times do you want it provided? That's not the same thing as saying that the court has no jurisdiction.
That jurisdiction for the boundaries review was transferred to, by an act of parliament, to IBC. So we were saying the court cannot hear what does not belong to the court.
So you see, you finally spent over 20 minutes.
Also, we are praying that
so you should not tell me that I'm biased because I'm not giving you enough time. Yeah, you spend more than 20 minutes to work.
Your Lordship, you understand we work for clients, and that is a county matter. So
I know you are accountable. I know you are accountable to a client, yes. But first and foremost, Mr. Osota, you are an officer of the court.
Yes.
Agreed?
I agree.
Yes. You see the way I was harsh on whoever, to Mr. Anyoka for giving his client wrong advice. So in court, you are supposed to, when the court gives us certain directions, you are supposed to follow them. Whatever your client says, we understand. Yes, who is coming next?
We are in a brief response to the recommendation by my brother on the issue of precision. He has cited the case of Nyamira. We are submitting that the petition has pleaded reasonable precision. The petition has fully complied 24 and 25, 24, 25, and 25 and 26 of the supporting affidavit, that's on page 38 of the bundle, of the petitioner's bundle.
Of the petition.
Petitioner's bundle. Is
I'm
in fact,
giving you
is
3
referred
minutes.
to incidents of harassment, incidents of injuries which were caused to some residents of Keroka,
Injuries.
and loss of property. Those are well particularized in the petition. So it qualifies as one having completed enough on enough position. Then very briefly on the issue of exhaustion. A petitioner is an individual. The Intergovernmental Relations Act deals with either counties
And I have that question to Mr.
it deals with either counties versus counties or national government versus
And
government.
not a government.
But this individual is not a government, that's the petition. So the doctrine of exhaustion does not apply to this particular individual.
Yeah.
So does not apply to the petitioner here. The doctrine of exhaustion does not apply to the petitioner in this particular case. The only forum available to this petitioner upon allegations of infringement of the various rights that I have mentioned is this particular court. So the court is fully seized on jurisdiction to entertain this particular case. That's it.
Minutes as well. Mr.
Yes, my
Mention it.
Maiche.
Mr. Maiche, yes.
Yes,
3 minutes.
on the position, I associate myself with the explanations of my senior. I will start submitting on Article 189. Article 189, Your Lordship, it talks about disputes between governments and how they shall be resolved, and it provides
It's on intergovernment.
yes. And then an act was enacted, the Intergovernmental Relations Act. And Your Honor, the Intergovernmental Relations Act defines what constitutes to a dispute or an intergovernmental dispute. And it says that it is a dispute between the national government and the county government or amongst county governments. Your Lordship, that is Section 30 of that Act. Your Lordship, the question then is this a dispute between governments? And Your Lordship, it's an emphatically no. This is a dispute between the residents of Keroka.
No, I'm not residents of Keroka here. I'm Nyamira Kisii.
It is Nyamira Kisii who has been petitioned by the residents of Keroka to under
It is Nyamira.
very well.
I don't know the others.
Very well, Your Lordship.
If they are in court, they are here as members of the party.
I stand guided.
So that politics you are trying to do.
I stand guided, Your Lordship. And Nyamira Kisii is an individual.
Point taken.
Yes,
Not a government.
is not a government. And Your Honor, to that effect, I give the authority of Okoiti versus Parliament of Kenya and two others, 2022, PKR, and at paragraph 73.
I think you have made a point, your point, that Gesara
Is not a government.
Is not a government. You don't even have to give me authority.
Yes.
Not unless is so amorphous, not to be
I move to Article 89, Your Lordship.
Yes.
And Article 89, 3 and 4, they talk about the review of boundaries of wards and the constituencies. Your Honor, in the Constitution where you find the mention of county boundaries is Article 93.4 and Article 188. And Your Lordship, in Article 93.4, it says that Parliament may consider and pass amendments to this Constitution and alter county boundaries as provided for in this Constitution. Now the provision, Your Lordship, is provided under Article 188. Article 188.1 says the boundaries of a county may be altered only by a resolution recommended by an independent commission set up for the purpose by Parliament and passed by the National Assembly with the support of at least 2/3 of all of the members of the Assembly. So it goes on talking about that. Now, Your Lordship, the question is there an independent commission which has been mandated through an act of Parliament to resolve these issues? Your Lordship, where we are at now, there is no commission. In the case
Can
of...
you look at Article 89,
Yes?
Sub-Article 10. What does it say?
Article...
Apply to the High Court for review of a decision of the Commission made under this article. What do you have to say about that?
Under this?
Any court person may apply to the High Court.
Yes.
So are you in the proper court on that?
That is Article 89.
Yes.
And Your Lordship, our submission is that we are not in court under Article 89. Yes. So, Your Lordship, before I lose focus, in Article 188, it talks about an independent commission, and the comment I had made as at now, we don't have that independent commission. And then I was giving the authority of the county government of Isiolo.
Your time is over, yes?
Yes. And Your Lordship, when you read that article, it says that it is not IEBC which is mandated under Article 188. Then it goes says that the learned judge Isaac Lenaoras goes to say that it is my opinion, therefore, that while the parties are right that Article 188 allows for an independent commission to alter a county boundary that is not IBC, that is not IBC. The article provides for the independent commission set up for the purpose by Parliament. In my understanding, this is a separate independent commission set up the Parliament, and it is not IBC, a constitutional commission. The rationale being that county boundaries go to the core of the territory of the Republic of Kenya as provided for Articles 5, 6, and the first schedule. Hence, the high threshold for altering the boundaries as stated in 188.1 of the Constitution. Then, Your Honor, at that point, there is no commission which has been established to consider the county boundaries. Then the question is, where do people go who have been aggrieved by the boundaries of counties? Where do they go? Your Honor, then the best recourse could be a court of law. And the court of law, Your Honor, is the court has not been given the mandate. It is a commission which is supposed to be set by Parliament, which has not been set. An independent commission, which has not been set. Your Honor, Article mandate under Article 89, very clear, concise. They are supposed to review the boundaries of wards and the constituencies. And then Article 93, Article 188 talks about county boundaries. That is where, Your Honor, the Parliament has
So if there is no IEBC
Yes.
in place,
Yes.
then I become the IEBC.
You become not the IEBC. If there is no independent commission in place, then the court is the best recourse. Because the environment, the Land and Environment Act, Section 13,
So
it
you are
talks.
saying the IEBC is not there because it has no commission.
Your Lordship, there are two things which we need to differentiate: IEBC and an independent commission.
Okay, and there has not been, the IEBC has not had an independent commission.
No, the IEBC is not mandated. It does not have the mandate, Your Lordship.
So when there is no,
Independent commission in place,
when there is no independent commission in place,
yes,
the court is
as jurisdiction, and
placed-
indeed,
placed with-
yes, because the Section 13 also talks, the court has original jurisdiction to hear any other matter, any other issue related to land, when you read that section. And your Lordship, this matter is an issue related to land, which is a boundary between Kisii County and Nyamira County, Your Lordship.
So where is that provision? Any other matter to do with land?
Let me... 2E.
Section 13 2E of the ESC Act.
Determine, yes, disputes and other disputes relating to environment and land. Section,
Any other dispute
yes,
relating
to environment
to environment
and land.
and land.
Yes, section 13.
Other
2E.
dispute. Yes. Now I'll stop you there. Next
Yes.
person.
Thank you, Your Lordship.
Please. Are you the last one?
Hopefully so. My Lord,
3 minutes as well.
that's okay. I associate myself with the sentiment which has been raised by my two colleagues
And add what?
in opposing the objection, and wish to add two issues. My Lord, the PO which has been raised is not a pure point of law. The form and substance of the petition
The issue raised,
by the second interested party
the second interested
party
party,
on the issue of rescission
on the issue
of the petition
of rescission.
is not a pure point of law.
Petition is not pure point of law. Yes.
As it requires that the court reduces from the pleadings,
Since it requires
the court reduce from the pleadings,
court to deduce
and analyze
from the pleadings
and analyze the facts.
analyze
The facts form an opinion,
court to form
an opinion whether there is precision or not.
as to whether there is precision
And that cannot be taken to be a point of law. My Lord, when you look at the Counsel, look at the petition, in terms of form and substance, there is the legal grounding of the petition. There are particulars of the issues which have been raised, and therefore the form and substance is proper.
form substance.
Is proper. My Lord, on the second issue,
Finally,
my Lord, on Article 89, I think there's a misconception in terms of this petition. The issue before you, my Lord,
is not for the court to order a review of the boundary. The boundaries have already been set, and they are existing. The dispute is to who is in the other party's area of occupation.
Who is encroaching?
Who is encroaching? That's the right one. And in this regard, alone, IBC, given the mandate that they have already set the boundaries, including the procedures and wards, which touch, as Ms. Manyange was talking about, is that once you set the boundary for the constituencies and the wards, then automatically you have actually touched on the county boundary. And the reason why, the court's wisdom, why it actually called in IBC was for purposes of pointing out where does the boundary lie between the two counties. It does not amount to a review of the boundaries, but rather to point out, and that's what the reason why the surveyors were called out to point out, not to review the boundaries from it. As far as my lord I'm concerned, is that these boundaries were set way back, I think in way back in 1992, by an act of parliament. So boundary rights is therefore does not. My lord, lastly, in resolving this issue, one of the principles which has been outlined in Article 159 is that at 159(2)(c) is that the court can consider an alternative forms of dispute resolution, which includes arbitration, mediation, and another judicial form which can resolve a dispute before it. And therefore, Article 159 is very much applicable when resolving this issue. Lastly, my lord,
Yes.
this court has its discretion to determine issues of occupation, use, and title to land, which includes boundary. And that jurisdiction has also been enhanced or has been amplified by Section 13 of the Environmental Land Act. And given the issue before you is about the location of the boundary, then this matter is squared before you properly and in the right forum. My lord, I urge the court to dismiss the case.
Any other person?
Yes, properly before this court. And what we are saying also is that this petition, this preliminary objection can only suffice and see the light of the day if the petition as provided under this various article, that's Article 188 and 189 of the Constitution, if the petition involves a dispute between the counties. That's if this petition was brought with from one county accusing another county of the boundary dispute, then we should have agree with the
So it's
PO.
between a private citizen?
Yes, it's between a private citizen and two counties, which are
That's
interested parties. They have no problem. I don't know whether they have problems.
Which are even interested parties.
Yes.
We do not know whether they have problems with one another.
And therefore, Your Lordship, the petitioner is properly before the court under Article 22, and also Your Lordship, that if this court under Article 162 has jurisdiction to entertain the petition, because as we speak, there is no any other forum which the petitioner can run to. And this morning, I've come to learn that there is a bill in Parliament that's Senate being debated today called County Boundaries Bill, which has not yet come to law, which I think at the fullness of time will address these issues. So we are guided in the direction of the court.
Matter or another dispute, as I envisaged in section 13, 2E, the provisions of the Constitution are very clear. Section 2E. So now the court can have jurisdiction. You can say this is purely a matter which they should have petitioned. Even that party, the petition, they should have petitioned the IBC. Finally, I say the submissions by Mr. Nyamira should be expanded. Reason is the IBC has not been admitted as a party. It's a procedural matter.
When did you check those that before he started making the...
I am just, that's my battle, Your Lordship. He is not a party. It's the court who has invited him to make those submissions. It's not a party in the matter. So,
or like last time we gave orders of what was going to happen to be done today. If you have raised your objections, that's simple. Because it's once the court has made an order, then the court is bound to follow that order unless there is a stay of that order from a higher court. So you waited until yesterday to bring the preliminary objection. You heard what I said about the IBC CEO, and I was very, very serious on it. Yes.
My colleague was very happy. He never said it's not a party, don't punish this person. He's now saying no way. He was very happy.
Your Lordship,
that's a fact. I deliver my ruling at 1:19.